Littleton Liquor Licensing Authority to come to order. Would you call the roll, please, Rochelle?
Authority Member Gallagher.
I'm here.
Authority Member Bradish.
Present.
Authority Member Cole.
Here.
Authority Member Gunia.
Present.
Authority Member Price.
Here.
Authority Member England.
Here.
Authority Member Odell.
Here.
Okay, we have a full house, so we have a quorum. The alternates will get to ask questions, but will not get to vote on any matters. Are there any additions or corrections to the minutes from last meeting?
No. I'll make a motion that the minutes be approved as submitted.
Second the motion.
All in favor signify by saying aye.
Aye.
Any opposed? Okay, that's unanimous. Approval of the agenda. Looks good to me. Can I get a motion for that?
I move that we approve the agenda.
I second.
All in favor signify by saying aye.
Aye.
Any opposed? That's unanimous again. Item 6G, renewal application for Meat Cochina Express Incorporated. Meat Cochina Express, 135 West County Line Road, Littleton, Colorado, 80129. And subparagraph 2, Meat Cochina Incorporated, Meat Cochina South, 1600 West Bellevue Avenue, Littleton, Colorado, 80120. Do we have anybody here from Meat Cochina? No.
This is in the structure of, or similar to, a probable cause determination, that there is an issue to have them show cause why their renewal should not be denied.
Okay, and as I understand it, they wrote a check with insufficient funds for the fees for the liquor licenses on both establishments, and have since paid in full in cash.
And the license is now renewed?
It's at the state right now.
Okay. But as far as the city's
As far
concerned,
as our part of the piece of the, as far as our piece of the pie, it has been forwarded to the state, and they are still actively allowed to sell liquor at this point. As far as the probable cause hearing, they were late in paying insufficient funds. I'd like to maybe recommend that rather than having a probable cause hearing on this, is that we have a letter drafted to send to them that will state that we're not going to tolerate this again.
It would be the city's recommendation that that letter give them information concerning what can happen for either a suspension through probable cause and then a show cause hearing, or through the emergency process should issues arise with finances, because those would be detrimental to the community, or could be taking advantage of the community, or mean that they're not a substantial business that can continue to operate. That would be the issue, that those issues could be raised should this occur again, or if they should have difficulty meeting their commitments with the finance department, which has also been an issue in the past.
Would you be willing to draft that letter?
Be happy to draft that letter.
If you,
Excuse me.
if you draft it, I will sign it.
This goes,
I will bring it to your attention for your criticisms first.
Okay.
this goes to character and reputation. And do we know why there was insufficient funds?
The bank couldn't honor it because there wasn't enough money in the account. I mean, it's one of those simple processes. Money goes in, money goes out, and this crust and the money was all out phase of the account would be the only reason that the payment wasn't made. It wasn't a stop payment. It was an insufficient funds. And the usual practice is to send those through twice. So I have not seen the checks myself. But even if it's just once, it's insufficient. But usually they're tried twice to see if there was something crossing that the bank could honor in that case. The different bases that go with these, it's not so much a character issue as it is the protection of the community, that they've fulfilled their obligations and they can continue to, and they can meet their debts as due, maintain lease or ownership of the property, and if they take in taxes, that they transfer them over, because the people who give them the tax funds believe at the time the representation is it will be turned over to the proper governmental authorities, and that would be somewhat of a deceptive practice on the public, which means that it might not be appropriate for them to maintain a license because it's not in the best interest of the public. Different than character itself of the individual.
Okay, so do we need to take a vote on this?
I think.
I'm sorry.
Can I just raise one issue? I do have a concern based on the letter we sent them January 30th, where we said failure to submit good funds may result in a hearing to consider the suspension or revocation. They did submit funds.
Right. I believe you have to make a determination under the facts as they exist now that there is insufficient evidence to go forward for a show cause hearing. That would be the current recommendation of staff based on the change in circumstances that occurred in the last 2 days.
Well, I'm thinking even to write them a letter saying that, you know, we're very upset about this or something, when we've said in the letter, what we want you to do is submit good funds, and they did that. Maybe that should be in this letter, the first letter, where we say something about the check bouncing, and do you know what I mean? Because
Well,
they've done basically what we've asked them
I
to
think the
do.
letter said we wouldn't have them before
Right.
the
Yeah.
authority.
The letter that I understood we were discussing was one that informs them of the issues that can be raised or consequences that can occur under the regulations and the state law for licensees should this occur in the future.
How long a time was it in between January 30th and the time yesterday?
30 in the afternoon was when it was paid.
So it's 6 weeks, roughly.
I think that should be part of the letter as well.
Yeah.
The issue of paying it with good funds that could be established immediately as good funds
Well,
is that any check would not be able to be assured would clear by the date of the hearing.
right, and I think that letter should state also that those funds need to be paid in full, on time.
With the information of what the possible consequences are for not doing so.
Right.
But not stating what in fact will be the consequence, but what are the available consequences.
Right, yeah, not as a threat, but just as an information tool for them. Do I need to take a vote on this, or?
Did they pay it in cash?
Yes.
Thank you. For both of them? Thank you.
If you want to do it by consent, if there is opposition, there can be
Well,
discussion
that's why I
about
want to
whether
check
there's
on that, too. Is there
opposition
anybody opposed to writing them a letter?
About the status of the law.
Not in opposition.
Okay, let's
It
just
should be an informational status of the law letter.
move forward with that.
Okay.
Any more questions or comments about this? Next order of business. 7A, findings of probable cause liquor code violation, schedule show cause hearing for A, International Marketing Corporation doing business as Fat Frog Cafe, 2530 West Main Street, Littleton, Colorado, 80120. As I understand, there was a altercation in this establishment, and the police were not notified.
Correct.
They were notified by one of the combatants.
The police report number is 2009-0605,
Right.
which appears as part of the packet you received as A under 7. I bring your attention to the paragraphs on page 3 of the report, where the bartender was interviewed, and the statements made by the bartender of her awareness of the controversy and that she was involved in stopping the controversy, yet she let the parties leave and didn't contact the police, and it was one of the participants that did notify the police some 30 minutes later.
Okay. Well, we all know that's against the city ordinance and the liquor code also.
It would be, the liquor code would be having an orderly establishment. The city ordinance would be the orderly establishment, and which is a part of that same ordinance that requires a notification to the police department. So it would be both under state law and city ordinance that you could have a probable cause hearing on this particular one if you find that there is reason to believe that a reasonable person looking at this law would find that notification to the police should have happened. A reasonable awareness, not necessarily a knowledge, doesn't have to be the person has personal knowledge, but has reason to know they should.
Okay, well, the bartender was interviewed. She did admit that it did happen there, and she did not call the police. Any comments or discussion about that?
I think it's pretty obvious
Yeah.
that we have a probable cause here.
I'll entertain a motion for a show cause hearing.
I move that we call them in for a show cause hearing in our April meeting.
I'll second.
Would you poll the authority, please, Rochelle?
Authority Member Gallagher?
Yes.
Authority Member Braddis?
Yes.
Authority Member Cole?
Yes.
Authority Member Gunia?
Yes.
Authority Member Price?
Yes.
All right. Item 7B, All Spirits LLC, doing business as Total Wine and Liquors, 6901 South Broadway, Littleton, Colorado, 80122.
The legal information on this, again, would be if we again go to page 3 of the report. This is report 2009-1089, and a person is claiming in this circumstance they do not have knowledge that the person was obviously intoxicated. The law in the area does not require the person to know for sure those things, but reasonably should know. It's not a defense to hear no evil, see no evil, speak no evil, and that's the standard for identifications as it should be for other factors. So this would be for selling to a visibly intoxicated person would be the issue that you would be looking at to determine if there is probable cause. That could be that you believe the person knew or the person should have known would be the mental state in this particular circumstance.
Okay, this is, I'm not sure, this isn't that clear to me. I'm not sure whether he witnessed the gentleman walking out of the liquor store. Is that true or no?
The officer witnessed him in the liquor store.
In the liquor store.
And contacted him to come out and talk with him. And from what appears to be an equivalent distance as the proprietor would have had, noticed all these indicia of intoxication, including the physical problems with locomotion that were close in time to the time that he walked into the liquor store, as the officer basically observed him from before the time that he got to the liquor store.
That's what it sounded like. He saw him stumbling down the street.
Yeah, that's what my confusion was too.
Well, he makes notes. He says, as a male crossed the street in front of my patrol car, I observed he had difficult walking, stumbled several times. He almost fell to the ground in front of my patrol vehicle. I observed he continued to stumble as he went to the liquor store.
Okay, so he saw him go into the liquor store and interviewed him as he got out of the liquor store.
Mm-hmm.
And he verified.
With a brand new 40-ounce bottle of beer.
True, but another factor is there was no physical impairment, disease process or other things that were noted, but indicia of being intoxicated were the ones that are repeated by the officer from close contact rather than distant contact, which is what you find on page 2.
Right.
That's from distance observations. The other is from close observations.
Okay, well, it sounds like they did due diligence on that. They followed him into the liquor store, interviewed him on the way out. He was bloodshot eyes, stumbling, and they ended up taking him to detox. So, doesn't state, I don't see a blood alcohol content on this. I guess he wasn't required because he wasn't driving. He refused a PBT.
Yeah.
The as far as the law goes, there is no way to get around the constitutional protection of his person for such a thing as taking him into detox, which is not a crime, but is for his own protection. A civil action or a civil act is what that would be. The time he would have to show he was sober would be to get released by the agency that had him in detox.
And at that time, he has to blow zeros.
He has to blow zeros, or he has to be in such a condition that they have a person who's sober who can take custody of him and keep him safe.
Okay.
I would make note also that the person that sold him the alcohol said he didn't think he was intoxicated at the time, but when the officer was talking to him, he said that he realized he was intoxicated.
Those are all
Because the officer
factors.
told him.
Because the officer told him, yeah.
Well, it's also interesting, there were 2 people present, and neither one of them noticed that he was intoxicated.
I think we have enough to at least have a hearing.
Yeah, any discussion on comments, discussion? No?
I'd like to hear their explanation.
You betcha. I'll entertain a motion.
So I'll move that we have a
Show cause.
show cause hearing on 8 April on the Santa Fe Tequila Company.
No.
Oh, you're
It's all spirits, total wine and liquor.
Oh, I'm sorry, I'm looking at the wrong one. I laid it down. You're right.
Okay,
I'll make a motion that we have a show cause hearing on all spirits liquor for 6901 South Broadway in Littleton, Colorado, scheduled on 8 April 2009.
can I get a second?
Second.
Would you poll the authority, please?
Authority Member Gallagher?
Yes?
Authority Member Bradish?
Yes.
Authority Member Cole?
Yes.
Authority Member Bunia?
Yes.
Authority Member Price?
Mr. Chairman, a question for the authority. Would that be on the basis of selling to a visibly intoxicated?
Yes.
Thank you.
Okay, next item of business, 7C, Santa Fe Tequila Company South LLC, doing business as Santa Fe Tequila Company, 2630 West Bellevue Avenue, Suite 150, Littleton, Colorado, 80123. And the issue with this, as I understand it, is that they are not going to do business there, and their lease has expired, but their license is still valid, but it can't be valid because they need to have the license owner has to have a lease or own the property that he's going to be selling alcohol on. Is that?
Here's they do not, the statement is they don't have a lease and that they aren't operating. Those 2 factors, if true, would be a reason to terminate the license if it's not surrendered. It was not surrendered.
Okay. Is that license, has it expired yet? No, okay.
But there does not appear to be any activity on it right now either.
Closed down.
Yeah, please. State your name and spell it, please.
My name is Steve Kurtz. I represent the landlord.
Would you spell your last name for us, please?
Kurtz, K-U-R-T-Z.
Okay, Mr. Kurtz.
This tenant's not doing business right now in the center. They have gone out of business. They do not occupy the space, and we're in the process of finding a new tenant at this time.
So it's not that their lease has expired?
No, they went
just-
out of business. Yeah. And so we're looking for a new tenant right now. And their liquor license at one point we were going to pick up, but I think we would just let it expire, and then whoever we find for a new tenant would then step in and probably apply for a new license at that time.
You know, that license does have some value.
Well, my understanding is it'd take about $4,000 to put it in our name and another $4,000 to put it in another name.
Okay.
If there's a way for us to hold that license somehow in limbo until we find a new tenant who would use that license, that would.
When is that license due? Now, you can transfer the name of the license, but is that costly?
Brand new license.
Exactly the same as a new license.
Does it?
Yeah.
So,
Transfer a license, you have to be operating. That's why you transfer it,
Right.
is so that the location can keep operating. I would need to see a presentation to the authority that the fact that it isn't operating at this time and there isn't a lease at this time allows the license to remain valid. I think that's what the show cause hearing would be for, just show if they can establish.
but if you're not concerned with keeping that license alive, then I'm not concerned with it either.
Yeah, I think these guys are out of business and they're not going to come to a show cause hearing.
Now, in order to terminate the license, do we need to have a hearing, or can we need an affidavit of surrender, or?
When does that license due to expire? I think it's somewhere around March 17th, if I'm not mistaken.
This year?
Yeah.
Yeah. I think you might be right.
Because I recall
It's pretty.
yeah,
went on pretty
because
quick
I
here.
thought it was them and the Celtic Bar I signed their licenses. Huh?
June 11th.
June 11. Oh, okay.
It took a while for it to go through the city.
It took a while for them to get through. That's right, because we had an issue with his identification.
Well, and he didn't open until probably August.
Right.
Although this gentleman has the property, Mr. Kurtz, the licensee is still the licensee. They haven't
Right.
surrendered, so
So let's do a show cause hearing.
to give them an opportunity to come in and show cause.
Okay.
That's fine. I just wanted to let you guys know what was going on. so
Yeah.
you knew.
We had that information. You gave it by telephone. We believed it then.
Okay.
There's nothing.
Yeah, we believe you, sir.
Okay.
Thank you,
All
Mr.
right.
Kirk.
Thank you very much.
You had it by phone. You must have talked to Jonathan then.
Yeah, Jonathan Bush.
Okay.
Okay, thank you, sir. All right, I'll entertain a motion.
I make a motion that we hold a show cause hearing for Santa Fe Tequila Company South LLC.
Would that be a hearing to revoke the license?
Would be it would be,
It would be to
Yeah, it would be
suspend or revoke as
revocation.
normal, and the basis in this case would be, do they qualify to maintain a license?
Right, because they don't, their lease is expired.
Oh,
Or they're not in
operating.
business and they're not, okay.
There may be a number of issues that they have to address to reestablish that the license should remain.
You know, if they don't show up, they forfeit.
Well, the license is in the name of the LLC, which may not even exist anymore.
Well, yeah, but I do know that there is a Santa Fe Tequila Company on like 9th and Lincoln.
No, it's closed too.
They're close too?
Yeah,
Oh, is that right?
They closed both like.
Oh, okay, okay. All right, so we have a motion?
really sure. I forgot. I did make a motion that we hold a show cause hearing for the Santa Fe Tequila Company South LLC doing business as Santa Fe Tequila Company, but I don't know if the address is valid. So I do
20
make a motion we hold a
2630 West Bellevue?
Yeah,
That's where the license
That's where the license
premises
is, that's the address.
that's what we use, yeah.
All right, then, we're going to do this one more time. I make a motion that we hold a show cause hearing for the Santa Fe Tequila Company South LLC, doing business as the Santa Fe Tequila Company, South 2630 West Bellevue Avenue, Suite 150,
Littleton, Colorado.
Littleton, Colorado. Good enough?
Good enough.
All right.
I second the motion.
All right, would you poll the authority, please?
Voting Member Gallagher?
Yes.
Voting Member Bradish?
Yes.
Voting Member Cole?
Yes.
Voting Member Gunya?
Yes.
Voting Member Price?
Yes.
Okay. Next item of business, liquor license application hearings. Amendment to the application for item 8A, the Blue Mood Lounge Incorporated, doing business as the Blue Mood Restaurant and Lounge, 5950 South Platte Canyon Road, B 18 through 22, Littleton, Colorado. we have someone from the Blue Mood here.
Everybody.
Audio, so,
Okay, let me ask a question here real quick. Number one, would you please identify yourselves for the record?
My name is Mark Thomas. I'm the landlord.
Mr. Thomas,
I'm Teresa Bentley. I'm the general manager.
Ms. Bentley,
Timothy Bentley, bar manager.
Mr. Bentley. All right, thank you. Now, I have one question here. You have applied for and have been granted and approved a license at one location in the shopping center, and you've decided to move it to a different part of that shopping center, correct? And in your doing that, you had to pretty much reapply for the whole license thing again? Yes? Okay.
Had to do everything, just the repetitioning of the paperwork.
Repetition, et cetera, and this is the petition that you gotten from Oedipus Incorporated, and the representative from Oedipus is not able to join us today, but that this is a favorable petition in favor of the move?
Yes, in fact, it was slightly higher than the last time we petitioned, so I guess they found a few more people that were interested in it.
there is, I would tender A, B, C, and E for the exhibits for this hearing. The E is the only original one, the rest are copies.
Okay.
May I offer a correction? The application is being shown for B 18, B as in Baker 18 through 22. It's actually D as in David 18 through 22. It's a different building.
That's what I have it as, is D.
D? My copy says D.
D 18 through 22,
D as in
in dog.
dog. Okay. All right, I need a motion to accept these exhibits A through E.
What was E?
E is the list of the hearing roster, which is empty.
I'll make a motion, we accept Exhibit A through E.
I second.
All in favor signify by saying aye.
Aye.
Aye. All right. Any opposed? Nobody's opposed.
My question would be on the petitions that went through, did they identify the right location in the description of the shopping center?
I believe they did, yes. Just the agenda tonight identified the,
On the
On the agenda.
on the survey here, it is correct. D 18 through 22.
just for the record.
The staff position is that the company that did the petition has an explanation on how it was conducted, and based on previous contacts with the authority, this authority could take that hearsay information and consider it as sufficiently valid unless it is questionable, to accept it as if presented by the individual. And if not, then what we may do is pass on everything else, but have that information from Mr. Scott brought in at a later time as soon as he's available, or do so by telephone at a special meeting.
Okay. I have a question too. Your scope of business is going to be the same. It's not going to be turned into a strip club or anything like that. Very good.
When we originally, we started this in August of last year, and we had a hearing in November of last year.
I remember well.
The economy changed. We had a tenant that was interested in taking part of this space. That deal fell through. We almost literally picked up the conceptual floor plan that we had for the one building and put it over into this building. It'll provide a little bit better exposure, and it's space that we had demolished for where we were going to build the Starbucks, so it's raw shell space. We can just build it, plug one tenant into the space now, not have to build spec space.
Is this new location where the muffin place was?
This will wrap around the muffin
Okay.
muffin store. If you see the muffin space from Bowles, the muffins is on the right-hand side of the building. There's a blank wall, which is, we're going to punch a storefront through there. There are already two patios that are out there. We're going to expand their patio a little bit and finish the landscaping around that. It's already been submitted to planning, and they've reviewed everything. They're in the process of reviewing everything right now.
Okay, and identified on this drawing here, this hard line that goes around the thing is where you're going to sell alcohol, or are you going to expand the alcohol to the patio area?
Patio area will be used as well. It'll be fenced.
It'll be fenced.
And it's actually, the patio is smaller in this location than was previously approved over in the other building.
Okay, and the fence that you're talking about is the same thing that we approved the last time that you were here? Okay.
I have a couple questions. We're talking about the same owners,
Yes.
same operators, bar and everything. I have a couple questions on this drawing, if I may. The fence, it says you have a metal fence. Does it go all the way around it, or where does the metal fence?
approach, sir?
Excuse me?
Yeah.
May I approach? You pointed out. It's basically going to be,
Around the outside patio.
yes, sir. That right now there's two separate patios, but the space in between will be,
Okay.
and the fence will, right now the patio is this white part, but dashed lines are the proposed addition to our patio, and the western edge of our fence will be right on that
Okay.
line. Just as shown by the dark line.
What happens to this quote
This
existing
is the
patio?
I think we need to
That's
get
what a
both,
muffin is?
the conversation needs to
Okay.
be recorded, so each pick up a microphone up there, or
This is going to be the muffin place here? Or,
Actually, sir, there's two patios, and the muffin shop has their own on the west, and we have ours on the east.
And then what is this?
This is the actual muffin shop. We basically are wrapping around.
okay.
for the record, I think we should put in muffin shop in that space on the original, which we have here, so that the record will be complete, because the audio and the video is not picking up.
Not
what
showing
you're
it,
pointing
okay.
at.
Sorry. Also, I'd like to, it shows a ramp going from the muffin shop up into your area?
No, sir, that's actually just written there for space savings. The ramp is part of our stage for ADA purposes, but they just wrote it over in the muffin shop.
See, the arrow points to the,
There's an arrow pointing to the ramp.
That's an arrow
Yeah.
to where the ramp was, okay.
So they can display it up there.
Doors or, doors?
Right here at the vestibule.
You got three of them up here?
Just the one. That one will be hardware removed and the door left in place.
On the drawing we have,
if you want, we have a drawing here that might be, it'll show up there.
Hopefully it will.
You getting that, Wilton?
on the drawing we have, it shows three doors on, which side is that, the southwest side?
Southwest elevation.
So there's three doors on the southwest side. You're saying one of those doors is going to be removed?
Yeah, actually, it looks like this is drawn incorrectly. Looks like they've left this one. but
Can you
actually-
indicate on the,
Thank you.
oh, all right.
When it come up, then we'll be able to point it out. and
Basically,
then-
we're going to have doors here.
Michelle, can we zoom in on that?
He's doing it from up there.
Pardon? Wilton, can you zoom that in?
It's still loading.
Okay, all right.
Whoever's going to be doing the talking,
Now, are we ready?
No. There we go. All right. Perfect.
It's upside down, sorry.
Okay, you're showing three doors there on the southwest side.
The southerly door will be a service entrance door. This hallway feeds into the kitchen, so this will be the service entrance. The door next to it is the door that feeds into the vestibule, so that'll be the main entrance for the suite. The third door, I don't know whether that'll actually exist or not. If it's required by fire as a secondary fire egress point, then that's what it would be for, but it won't be
For entrance, it won't be for
won't be a
entrance.
separate entrance, no. No.
And these two doors on the other side are going to be for fire and supplies or whatever?
These are in the rear of the building?
Yes.
Those are existing doors that will be for probably secondary fire access. I'm sure fire will require it.
Okay.
there's also one by the patio.
Patio,
Now,
right, a
there
double
will be a
door.
door that will be, where am I? There will be a new storefront that will be punched into the wall along Bowles, so part of the tilt-up concrete will be removed, and then this door here will be put in. That'll provide access from the suite to the patio, and then the entire area around the patio will be fenced. So there will be a gate here, but just for secondary access, again, for fire. If this is a fire egress, you need to have a gate in here to get out.
That'll be another exit door, but not an entrance door.
Correct.
Okay.
There will be no way in from the street over here. All patrons will have to come in through the main door through the vestibule here.
Okay. Does that answer your question? Okay. Thank you. All right. Well, you haven't been involved in any criminal enterprises since the last time we approved this. Do we have any further questions or comments or discussion?
Everything's the same kind of food you were going to serve,
Same menu?
same blues?
Yeah, we're going to do jazz and blues. We haven't changed the menu at all, but I did bring the brunch menu with me tonight because I didn't have that last time. I didn't know if you guys would want to see that.
You bet.
And the only other thing that we brought, there was some discussion at the last hearing regarding our liquor policy. The one we had submitted with our application was slightly different than what we had submitted that evening. So what I did today is I brought back the original one, and the only thing that's different is, I'll bring it to you, but on item 4, we added the city ordinance that the management would contact the police if an altercation occurred.
So that's a practices information sheet that everybody who works for you is going to have.
Correct. They'll sign, and we'll keep that in their employee file.
Okay.
And I don't know if you need a copy.
I understand also, as I recall, you're a certified tips trainer. Is that true? And some of the other establishments in the city have contacted you regarding tips training?
They have not, sir. I just said in the last meeting that if any of them wanted to send their people, they would be more than happy to sit in, and I wouldn't charge them any fee for my teaching of it. Of course, they have to pay tips for
Right, yeah, right, I understand that.
Plan to continue.
Well, I thought we had one, thank you. I thought we had one, Rochelle, didn't we have one establishment that was going to talk with Blue Moon about tips training?
Send the referral, but they found the training through the tips place faster.
Okay. All right. Okay, any further discussion, questions, comments?
I'm curious as to how this affects your opening date. I think you planned to open in June originally, or was it sooner than that?
We were going to try and get them open by March. The last time we went through this, we actually went out and did cost estimates on the space, and we had this other tenant fall out. It pushed us back a little bit, but we have spec'd our time on putting together all the architectural plans and engineering plans. So if things work out this evening favorably, we are ready to submit, and we probably will lose maybe 30 to 45 days, but the contractors their schedules are a little bit freer these days as well, so we can probably pick up some time that way.
Thank you.
Okay. Can I get a motion?
I make a motion that we approve the change in location.
Second.
Would you poll the authority, please, Rochelle?
Authority Member Gallagher?
I agree.
Authority Member Braddock?
Yes.
Authority Member Cole?
Yes.
Authority Member Gunia?
Yes.
Authority Member Price?
Yes.
Okay,
Good luck.
thank you.
Thank you. Congratulations.
Again, hopefully you won't be moving around too much in the near future.
All right.
You're free to go.
Next item of business, show cause hearings, we have none. General business, discontinued court reporter for hearings. And Rochelle was explaining that before the meeting. And I guess the issue on that is that we no longer need to have a court reporter because we are recording it and televising it and et cetera. So I guess we don't have a problem with that. Mr. Katz, you have a problem with that?
There's no legal impediment to doing that. The county courts in the state of Colorado currently use recordings. The municipal court here, which is a court of record, also uses recordings. This recording, because we have exhibits that can be blown up, we also have those exhibits physically. So even if we weren't making a video recording of this, the audio would be sufficient for legal purposes for any appeal or review of the actions of this administrative agency. And since we do have the video that will go with it, even though it doesn't add to the evidence itself, it would be part of the record if anything was appealed. So actually the record would be enhanced if anything. There may be, if something was appealed, there would be a cost for a transcript to be created for the district court.
As opposed to a cost every time we have a court reporter here.
But if we have a court reporter here, there's still the cost of making the transcript for the appellate court. They're not likely to watch the video. They're likely to read what was placed into evidence. They may watch the whole video, but the fact that they see it would not change what was said or done unless there's a dispute about the record. And if there's a dispute, it's the obligation of the party that's disputing the record to supplement and ask for a specific thing to be done by the appellate court.
Okay. So basically, we don't need the court reporters anymore. All right. 11A, staff have any reports? No?
The reports I had, you reviewed for probable cause.
Okay. The authority members have anything to report?
No.
As chairman, I have nothing to report. We're adjourned.
We were told to report here tonight for the Fat Frog Cafe. We were given notice of that.
Yes, and you'll have to come back next month because there's going to be a show cause hearing for that. This is a probable cause hearing, and you don't get to testify in a probable cause hearing. We look at the police reports and determine whether we want to come in and bring you in for a show cause hearing to see if you can show cause why we shouldn't suspend your license. No, sir, we hadn't made that determination when you were notified of the probable cause hearing. So we weren't required to show that? No, you were not required.
We were required to give you notice that your issue was going to be on the agenda so that if you wish to attend, you could, to see what information transpired at this meeting. But there wasn't evidence being taken from witnesses and otherwise, and that was within the letter of February 13, 2009 that you should have received. But this is a public hearing, and you always have a right to be at a public hearing. And you could have signed up to speak on an issue, and you may have been granted time to speak on that, but they weren't taking specific evidence on this issue today because probable cause is a much lower standard than the show cause, which has a burden to present some evidence to establish that there's a violation.
So in the show cause hearing, what will transpire then?
Well, we don't know what's going to transpire. We'll look at the evidence, and we'll decide whether that's the time that you come with your witnesses, and you get to tell your side of the story. Right.
All right, thanks very much.
Okay.
If you need subpoenas to have your witnesses come, they should be issued, and so they can be ordered, because this authority has the authority to command the presence of a witness just as a court would. If you have
Thank
issues
you.
about those subpoenas or that, you should contact Ms. Work about that, and we can give you some more details and forms that will help you get those things done.
Sorry about the confusion. Okay.